Hello. One of the questions I get asked most often, and one of the reasons I am retained most often by service members and their ex-spouses, is to divide or otherwise allocate the military retired pay of the service member. This is by far one of the most difficult and misunderstood areas of military divorce law. And so we're going to spend several blogs here talking about some of the both big picture items, but also some of the really detailed and complex smaller issues that have a really significant impact on the division of benefits. So the first thing we're going to address is what's known as the frozen benefit rule. First, I want to give a little background on the concept of military retired pay in general. So I think it's safe to say that most military couples feel that the military retired pay, or sometimes known as the military pension, is one of the most, if not the most, valuable financial benefit that military service provides. It usually is paid out once the service member retires after 20 years, that's the minimum, 20-year retirement from service. And certainly after that time, a lot of benefit has accrued, and it can be a very valuable means of financial support for the couple in the future. But what happens when the couple divorces? Well, all states allow for the division of the military retired pay as an asset. It is considered a pension, a defined benefit plan, and therefore is considered an asset to be divided at divorce. However, there are very different ways addressed by the states of approaching this question of how to divide it. The first and most basic is the one addressed by most community property states, indicating that the entire pension, regardless of when it was accrued, is to be divided usually equally. At least that's the starting point. Another way to address it is for a state's law to indicate that we're going to separate out the part of the military pension that was accrued prior to the couple getting married, if there is such a portion, and we're going to award that to the service member, and then the amount of the pension accrued during the marriage is going to be divided between the couple. Those are just two ways of dealing with it. There are others, but in large part, those are the two main ways of handling a military pension. But the federal government usually stays out of questions of divorce or property division in divorce and family law in general, but sometimes makes an exception for specific items, and issues regarding divorcing military couples are sometimes one of those exceptions, like there is with this frozen benefit rule. This rule was passed in 2016, and the main purpose is to bring some clarity to a very specific question regarding the division of military pension. So what the Defense Financing and Accounting Service, usually called DFAS, was finding, and what I find very often in my work, is that when the order is drafted to divide the military retired pay and sent to DFAS, there was always a significant question as to should the ex-spouse share in the increase in benefits due to the service member's post-divorce increase in rank or increase in pay, etc. Again, states are kind of all over the map on that. And what I often see, and what DFAS was seeing, was either the divorce judgment was silent on the question, or it was drafted incorrectly and was leading DFAS to reject a lot of the orders to divide military retired pay because it either didn't address the issue or addressed it incorrectly. So the federal government has decided, according to this frozen benefit rule, to, in essence, freeze the benefit available to the ex-spouse at the time of divorce. So what that means is, in the divorce judgment, the ex-spouse is awarded some percentage or some number of the service member's retired pay if and when received. And so any increase in the benefit or the amount of the retired pay due to the service member's post-divorce service, increase in rank, etc., does not accrue to the ex-spouse. The service member gets to keep the increase in retired benefits accrued after the divorce. So there are two different ways to look at this, depending, of course, on which side of the couple you are. From the service member's perspective, of course, the concept being, listen, I have served in the military after the divorce, and you, ex-spouse, did not really contribute to my service after we split. So why should you share in the additional benefit that I accrued after the divorce? That should remain with me. From the ex-spouse's perspective, the argument certainly would be, yes, I did not directly contribute to your post-divorce service. However, for the time we were married, I did support you, whether it be through financial means, childcare, relocating through your various, if your orders sent you to various different mobilizations. So your subsequent increase in benefits, an increase in rank, could only have happened due to the support that we gave each other during the marriage. Obviously, there's two different ways of looking at this, but the federal government has come down on, as it often does, on the side of the military member in this circumstance, providing for this frozen benefit rule, indicating that after the divorce, increases in the benefit are solely given to the service member. It is important for your divorce lawyer to know the ramifications of this rule. The first thing that your order must indicate is what percentage, what amount of retired pay are you going to get as the ex-spouse, or obviously as the member, how much of your retired pay are you going to maintain and how much are you going to have to share? There are a lot of other issues to address, but you want to be sure that your lawyer is aware of this rule so that neither side of the couple has an expectation of a benefit in the future that simply cannot be paid to them. And I reiterate that I have seen many, if not most, of these divorce orders dividing military retired pay that are incorrectly drafted or simply silent on this question. Ultimately, what happens is many years after the divorce, when the service member is due to retire, the ex-spouse gets notice of that and then finds out that he or she may not be receiving what they were expecting from their portion of the benefits. So make sure this is a discussion you have with your divorce lawyer, and we will continue to address some of these very specific but very important issues as we proceed through the question of military retired pay.